Hi everyone, I'm Sabrina.
And I'm Jonathan, and we are the lawyers at Verity Law.
Today we will be talking about matrimonial homes. Did you know that even if your spouse is not on the deed to your property, but the house is considered a matrimonial home, then the spouse can still possess the property?
If your spouse can possess the property, this means you cannot sell or mortgage the property without the spouse's agreement. So Sabrina, what counts as a matrimonial home?
Well, simply put, a matrimonial home is the house that you and your spouse live in as your family residence during your time of marriage. Let's take the example of Sam and Anne. Sam bought a house in 2017 by himself, and he's the only person on the deed. In 2020, he got married to Anne. They started living in Sam's house right after the wedding. In 2022, Sam bought a cottage and put it under just his name. The married couple goes there to vacation almost every summer.
Then, in 2025, Sam and Anne get into a disagreement. Sam wants to sell the cottage and refinance their principal residence. Anne disagreed with both of these decisions and argued they should leave everything as they are.
Well, let's look at the law here. The 4 requirements for any property to be a matrimonial home are: first, the property is owned by one or both spouses. Second, the spouses live in the house as their family home or principal residence during their marriage. Third, the spouses must be married spouses, not common law partners. And fourth, the property must be located in Ontario.
In Sam and Anne's case, they have been living in Sam's house and cottage, and used both as family residences during their time of marriage and at the time of separation. Because of this, the court will likely find both properties to be matrimonial homes. Unfortunately for Sam, he requires Anne's consent before he can refinance or sell any matrimonial homes. He cannot make those decisions by himself, even though his name is the only one on the deed.
So when Sam does go to a real estate lawyer to try to refinance and sell the houses, he must legally swear that either Anne agreed to his decision or the house is not a matrimonial home. Otherwise, he cannot make those decisions alone.
As the couple reaches an impasse, they decide to get a divorce. Anne refuses to allow Sam to list the house and show it to potential buyers. As the spouse, she has the right to remain in the matrimonial home until their divorce is finalized.
But Anne must also be careful here. If at any time she decides to abandon the matrimonial home and live somewhere else, then she loses the right to stay in the house. So she must ensure she lives in there until the end of the divorce proceedings.
Now, what happens to the house once the divorce is finalized? Contrary to most people's belief, the house is not simply split 50-50 between Sam and Anne. This is because, after all, Anne is not on the deed, so different rules will apply. When Sam and Anne do separate one day, their net worth at the date of marriage is subtracted from their net worth at the date of their separation. This is called each person's net family property. The spouse with the higher net family property must pay the spouse with the lower net family property 1/2 of the difference.
So you definitely do not want to be the spouse with higher net family property. Unfortunately for Sam, because his name is on the deed of the family house, its full value is added to his net worth on their date of separation. The house value is not added to either spouse's net worth at their date of marriage. Almost always, this means the spouse on the deed, Sam, will have a higher net worth than the spouse not on the deed, Anne, meaning Sam will need to pay Anne 1/2 of the difference upon separation. So even if Anne agrees to sell the house, when the sale is completed, the real estate lawyer must keep the sale proceeds in the trust account and wait for either a divorce court ruling or a divorce agreement to be signed by both parties. Only then can the real estate lawyer distribute the sale proceeds accordingly.
However, any other property under just Sam's name that is not a matrimonial home should not be affected. For example, let's say in addition to the family home and the cottage, Sam bought an investment townhouse under just his name. Sam and Anne never lived in the townhouse, and it has been rented out to tenants since Sam bought it. Then, since it's clearly not a matrimonial home, Sam can sell, mortgage, and do as he pleases with the townhouse without Anne's agreement.
So whether or not a property is a matrimonial home is very important. What if Anne claims the townhouse is also a matrimonial home?
In that case, Sam could provide evidence that Anne never lived in the house. But more easily, Sam and Anne should have done a matrimonial home designation when they first bought the houses. This means they choose one house to be the matrimonial home, their family home, for example. And they register a declaration with their real estate lawyer confirming that only that house is the matrimonial home. Once registered, any other house is automatically not the matrimonial home and would only recognize the owner on the deed. This means both the cottage and townhouse would only be owned by Sam, and Anne would have no say in the matter.
Well, it's kind of late now. What if Sam comes to do the registration after they already started divorce proceedings?
In that case, it is not useful for Sam. Because registration by only one spouse only confirms that the family house is a matrimonial home, it does not mean other properties are not matrimonial homes. But registration by two spouses means all other properties are not matrimonial homes.
Okay, so registration is actually useful for Anne, not for Sam. If Anne wants to protect her interest in the family home, she should immediately go to a real estate lawyer and register this declaration. She must do so before she moves out of the house, before Sam sells the house, and before divorce proceedings are finalized. She cannot do a registration after any of those have already happened.
Yes, so Sam should have acted immediately after he bought his properties by registering the matrimonial home designation with a real estate law firm. Anne should immediately act after the divorce has started to protect her interest in the family home before Sam sells it or the divorce is finalized.
Okay, so, but what happens if the cottage is not under Sam's name, but is under his parents' name? Will the cottage still be a matrimonial home?
In most cases, it would not be a matrimonial home because the cottage is owned by Sam's parents, not by Sam. However, we must look at whether there is a landlord and tenant relationship between the parents and Sam. Does Sam pay rent to his parents? Are the parents responsible for major repairs, renovations, and paying property taxes?
If yes, then Anne definitely does not have a claim. But if no, then Anne could argue that Sam acted as a property owner to the cottage even though his parents were the ones on the deed. This is a hard argument to win, but there is a possibility of success. To avoid this, Sam should ensure he and his parents have a clear-cut landlord and tenant relationship.
Lastly, what happens if Sam passes away? Would all three properties go to Anne?
Well, definitely not the townhouse, as that is under Sam's name and is not a matrimonial home. The townhouse will be distributed according to Sam's will, or if he doesn't have a will, according to estate legislation. Keep in mind though, if there is no will, the spouse will get the lion's share of Sam's estate according to the law.
So Sam definitely needed to get a will done immediately after he bought the real estate. What about the family home and the cottage?
Well, Anne has 6 months after Sam passes away to claim for the family house and cottage as matrimonial home. If no claim is made in 6 months, then Anne must follow estate law.
Okay, so Sam is distressed as he paid for all three properties, yet two properties are deemed matrimonial homes, and the spouse would get a big chunk upon divorce. What should he have done?
Well, first, if he borrowed any money from his parents to buy the properties, his parents should go to a real estate lawyer and register a mortgage in their names. That way, at least their money is protected from being split. Second, as soon as Sam bought his second property, he and Anne should go to their lawyer and register a matrimonial home designation. That way, only the first property, the family home, is the matrimonial home. No other houses are matrimonial homes.
Of course, Sam and Anne could also decide not to get married. The division of property only applies to married spouses, not common law partners. As for Anne, if she wants to protect herself, she should try to go on the deed to the properties. If she cannot do so for mortgage reasons, then she should register a declaration of matrimonial home as soon as divorce started to protect her interest in the family home before Sam sells it.
Okay, that's all for matrimonial homes. We hope this video is helpful. We will see you next month.